Okay, next case. Jean is 86 with 3 daughters. She appoints the oldest, Suzy, as her successor trustee and her agent. The other two, Mary and Beth, decide they don't like Jean's decisions and bring an action to have her declared incompetent, to have the appointment of Suzy set aside, and to have themselves appointed to manage her affairs. Suzy lives out of state and is not aware of what has happened until she finds large sums missing from Jean's accounts and then has her access cut off. What could have been done to avoid this problem?
Well, this is a little bit similar to the previous case in that, by having everything executed, the will executed with an attorney or the trust, we go through a process for, as you guys know, we visit, we talk to the issues. If there's any indication that competency may be an issue, there are additional procedures that we can apply to satisfy ourselves and your family that everything is proper. There's situations where we might videotape or the execution just to stave off any potential claims that other family members might have, which, as you know, they wait until someone's passed away before they make those claims. So that's something that is really important to use. So a law firm such as ourselves, we try to identify those issues. Going back to the last question, if it was a handwritten will, there's no one there that can attest, no witnesses, no one can attest as to the competency of the person signing the document. So,
good point. This particular case went to court, and Mom became all flustered. If you can contemplate this, you've got an 86-year-old woman who's being put on the witness stand and attacked by her daughters. Can you foresee her becoming flustered? Well, Mom does. She becomes flustered. The court says, I can't determine whether she's competent or not, so I'm going to appoint a CPA to manage her finances and an attorney to make all of her health care decisions for her while we wait to see whether she's competent or not. Could this have been avoided?
Well, it raises a couple issues. Number one, we have access to experts that could help prepare the mother for that hearing. Rather than go at it blindly and expose her to whatever line of questioning the attorney or the other side may have for her, there's some preparation that can go that we can get involved with that will make that process smoother. The second issue, again, is just trying to maintain the mother's control over her own affairs. So he mentioned they're trying to appoint a CPA and other people involved. Again, back with ensuring that you have valid, durable powers of attorney in place, including advance directive for your life decisions. Make sure that those are up to date, those are valid, they're not too remote in age that they're not going to be upheld. That allows, in this case with a law's mother, or in your case, to maintain control over who makes your decisions and what type of decisions in the event you're unable to do so.
Good point. Well, this particular case has been in a contested guardianship for over 3 years. Suzy doesn't think her mom is incompetent, and if she is, Suzy should be responsible for managing her affairs for her because that's what her mother wanted. Her 2 sisters insist Mom is incompetent, and only they should be appointed. No one is willing to compromise. The court has required a battery of tests, and so far the case has already cost Mom's estate approximately $100,000, and it's still ongoing. What could we have done?
Well, in this case, you'd love for the attorneys on both sides or the families on both sides to get together, reach a compromise, hopefully something that minimizes the damage to both sides. But really, this just illustrates just how expensive it can be. Something as seemingly simple as just having an updated power of attorney and related documents that protect you and maintain control of your affairs in the event you became incapacitated or unable to do so. So in this case, the family paid a pretty steep price for that.